Magandang araw. In this video, we will be talking about the concepts of conjugal property versus community property. Okay? In succession planning, it is important for us to know the distinction between the two, the conjugal property and the community property. But before that, let us define first what is succession. Succession is a mode of acquisition by virtue of which the properties, rights, and obligations to the extent of the value of the inheritance of a person are transmitted through his death to another. Okay? There must be elements that must be present in order for succession to exist. Okay? Number one is the death of the decedent. So the death of the estate owner. Okay? And the inheritance, these are the subjects. Inheritance could either be properties like cash in bank, house and lot, businesses, buildings, condominiums. So these are the properties. Or it could either be rights like a right to pursue a law pending decision by the court, or the royalty rights or the copyrights. So pwede yang ipasa sa mga heirs. Okay? And also obligations or the liabilities. So hindi lang properties, hindi lang rights, even liabilities of the decedent or estate owner can be passed on to the heirs. Okay, and the successors, these are the heirs, like the children or the spouse or the parents in the absence of children. Okay, there are three kinds of succession. Number one is the testamentary or testate, when a person dies with a will. Okay, that is called testamentary. And when a person dies with no will, so yung magpiprevail is under operation of law, and that is called legal or intestate. And the third one is the mix. Okay, so paano nangyayari yan? Affected partly by will and partly by operation of law. Let's say for example, previously meron ng last will and testament sa estate owner, and then afterwards, after several years, hindi pa siya nawala, nakapag-accumulate siya ng another set of properties, rights and obligations. Okay, those properties, rights and obligations not included in the previous last will and testament will be subjected to legal or intestate, and those properties that were included in the last will and testament will be subjected to testamentary rules. So meron kasing different rules yan. Meron kasi tayong in testamentary or testate, when a person dies with the will, meron tayong tinatawag na free portion. So yung free portion na yan, the estate owner can give those properties free option to any person he or she wants to give to. So hindi siya restricted. As opposed to legal or intestate, when a person dies with no will, 100% of the properties of the estate owner should only be distributed to the legal heirs or the compulsory heirs. Okay, so yun yung distinction ng dalawa, whether when a person dies with will or without will. Okay, benefits of having an estate plan. Number one is reduces family conflicts. So paano nagkaka-conflict? Kasi if wala kang estate planning, wala kang last will and testament, kasi upon death of the estate owner, lahat ng properties mo, house and lot, businesses, buildings, condominiums, cash in bank, will be automatically co-owned by the heirs, by the siblings, by the spouse. So walang naka-earmark na properties, who will get what, who will get this. So therefore, a conflicts will most probably arise because of absence of estate planning. The second, the benefit is the accessibility of assets and documents. It is very important na meron tayong love drawer where our financial documents are stored and can easily be accessed during emergency. Ensure that your estate is intact and protected. Okay, so those properties were accumulated by our parents, ancestors, because of the hard work. So it is also equally important to protect those properties from being depleted due to payment of unnecessary expenses like the estate tax. So, kasi pag meron tayong estate planning, we can legally reduce the estate tax by incorporating appropriate tool to prepare for that estate tax. Kasi yung estate tax, kailangan bayaran yan before those properties can be transferred to the heirs, to the siblings, to the children, to the spouse, or to the parents. So kailangan bayaran muna yung estate tax. What if walang liquid assets yung family? So the tendency is mapipilitin silang ibenta yung other set of properties. So sayang yung napundar na property, or especially kung meron yung sentimental value to the family. Okay? Transfer of properties efficiently and effectively. So yun yung mga among benefits of having an estate plan. Now, we go to the main topic of conjugal versus absolute community. So ano ba yung magpiprevail? Is it absolute community or conjugal partnership of kings? Okay, the rule is that in the absence of prenuptial agreement, the reckoning point to consider is the date of marriage of the couples. Okay? Couples who were married prior to August 3, 1988, yung magpiprevail na property regime is the conjugal partnership of gains. And those who were married from August 3, 1988, effectivity of the family code onwards, the property regime that will prevail is the absolute community of property. So ano yung difference niyan? Under the current property regime of absolute community, lahat ng properties mo during your single days and then nag-asawa ka na, automatically those properties are also shared to your partner or to your spouse. So magiging community property na yun. The same with those properties accumulated during the marriage. So before and during the marriage will be co-owned by the spouses. Whereas under conjugal partnership of gains, yung mga properties mo, exclusive properties during your single days, shall remain to be your exclusive properties. Only those properties acquired during the marriage shall be considered as conjugal property. Okay, so what are the exclusive properties naman? So under absolute community, properties acquired during the marriage by gratuitous title. So let's say married ka na and then meron kang namana from your parents or meron kang donation na na-receive during your marriage. So those properties are classified as your exclusive properties. So capital for the husband or paraphernalia for the wife. Okay? Property for personal and exclusive use of either spouse, like the clothes. So mga exclusive properties yan. Properties acquired before the marriage by either spouse who has legitimate descendants by a former marriage. Let's say, for example, meron kang previous marriage and then let's say, naging widow ka or naging widower ka, tapos meron kang mga anak, so meron kang properties during those times and then nag-asawa ka ulit. So anong mangyayari sa mga properties mo? Will those properties be shared to your second spouse? Under the law, hindi, provided meron kang legitimate descendants. Okay, so those will remain exclusive properties of the uh, widow or the widower. Okay, yun yung exemption to the rule. And under conjugal partnership of gains, that which is brought to the marriage as his or her own. Yun nga, yung sinabi ko kanina, exclusive mo during your single days, then nag-asawa pa, those will remain exclusive properties. That which each acquires during the marriage by gratuitous title. So the same rule applies under conjugal partnership of gains. That which is purchased with exclusive money of the wife or of the husband. Okay, kung binili mo siya using your exclusive money, those are classified as exclusive properties. Okay, so for our next video, we will be talking about the who are the legal heirs or the compulsory heirs and how much is their legitimate or rightful share under the law when it comes to distribution of inheritance. Thank you for listening and watching. Have a nice day. Bye.